2015 CR 10230 State versus R.C. Curtis. Could I have parties announced for the record, please, for the state?
Stephen Spear for the state, Daryl Harris for the state, and Alexandria Bacchus for the state.
For the defense?
Charles Buck, Lindsay Shaw for Mr. Curtis.
And are you Mr. Curtis?
Yes, ma'am.
All right. Have both parties had a chance to review the charge of the court?
We have, Your Honor.
Yes, Judge.
Any objections from the state?
In its current form, no.
Defense?
No, Judge.
All right. All right, so I've been informed that all the jurors are here. Are both parties ready to proceed?
State is ready.
We're ready, Judge.
All right, let's bring them in. No. Is there anyone else who needs a charge? Okay.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, I'm going to read to you what is called the charge of the court. It's the jury charge. You do not need to memorize it because you will be given the original when you begin your deliberation. Charge of the court. Members of the jury, the defendant R.C. Curtis stands charged in count 1 of indictment with the offense of capital murder alleged to have been committed on or about the 21st day of October 2015 in Bexar County, Texas. The defendant R.C. Curtis stands charged in count 2 of the indictment with the offense of felony murder alleged to have been committed on or about the 21st day of October 2015 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual. Our law provides that a person commits the offense of capital murder when such person commits murder as defined above and the person intentionally commits the murder in the course of committing or attempting to commit aggravated sexual assault or robbery. 2. Our law provides that a person commits the offense of felony murder if he commits or attempts to commit a felony other than manslaughter, and in the course of and in furtherance of the commission or attempt or in immediate flight from the commission or attempt, he commits or attempts to commit an act clearly dangerous to human life that causes the death of an individual. The following offenses are felony offenses other than manslaughter: aggravated sexual assault, robbery, injury to an elderly individual, aggravated assault. 3. Our law provides that a person commits the offense of aggravated sexual assault if the person intentionally or knowingly causes the penetration of the mouth of another person by the sexual organ of the actor without that person's consent and the victim is an elderly individual. An aggravated sexual assault is without the consent of the victim if the actor compels the victim to submit or participate by the use of physical force or violence. 4. Our law provides that a person commits the offense of robbery if, in the course of committing theft, as defined below, with intent to obtain or maintain control of the property he intentionally or knowingly causes bodily injury to another. 5. A person commits the offense of theft if he unlawfully appropriates property with intent to deprive the owner of the property. 6. Our law provides that a person commits the offense of injury to an elderly individual if he intentionally or knowingly by act causes serious bodily injury to an elderly individual. 7. Our law provides that a person commits an assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault if the first person commits an assault as defined above, and 1. Causes serious bodily injury to another, or 2. Uses or exhibits a deadly weapon during the commission of the assault. A person commits the offense of aggravated assault causing serious bodily injury with a deadly weapon against a member of the person's family if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault and causes serious bodily injury to a member of the defendant's family. 8. Act means a bodily movement, whether voluntary or involuntary. Appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to effect the commission of the offense intended. Bodily injury means physical pain, illness, or any impairment of physical condition. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Elderly individual means a person 65 years of age or older. Family includes individuals related by consanguinity or affinity as determined under sections 573.022 and 573.024 of the Government Code. Under section 573.022 of the Government Code, two individuals are related to each other by consanguinity if one is a descendant of the other. Under section 573.024 of the Government Code, two individuals are related to each other by affinity if the spouse of one of the individuals is related by consanguinity to the other individual. The ending of a marriage by divorce or the death of a spouse ends relationships by affinity created by that marriage unless a child of that marriage is living, in which case the marriage is considered to continue as long as a child of that marriage lives. In the course of committing an offense means conduct that occurs in an attempt to commit, during the commission, or in immediate flight after the attempt or commission of the offense. Individual means a human being who is alive. Owner means a person who has title to the property, possession of the property, whether lawful or not, or a greater right to the possession of the property than the defendant. Property means tangible or intangible personal property or documents, including money that represents or embodies anything of value. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 9. A person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Count 1, capital murder. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of October 2015 in Bexar County, Texas, the defendant, R.C. Curtis, did intentionally cause the death of an individual, namely Paula Boyd, by strangling Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and or by strangling Paula Boyd with an object unknown to the grand jurors, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and or by striking Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, or with an object unknown to the grand jurors, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and R.C. Curtis was in the course of committing or attempting to commit the offense of aggravated sexual assault of Paula Boyd. Or if you find from the evidence beyond a reasonable doubt that on or about the 21st day of October 2015 in Bexar County, Texas, the defendant, R.C. Curtis, did intentionally cause the death of an individual, namely Paula Boyd, by strangling Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and or by strangling Paula Boyd with an object unknown to the grand jurors, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and or by striking Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, or with an object unknown to the grand jurors, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and R.C. Curtis was in the course of committing or attempting to commit the offense of robbery of Paula Boyd, then you will find the defendant, R.C. Curtis, guilty of the offense of capital murder as charged in count 1 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the offense of capital murder as charged in count 1 of the indictment. 11, count 2, felony murder. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of October 2015 in Bexar County, Texas, the defendant, R.C. Curtis, did commit or attempt to commit the felony offense of aggravated sexual assault, in that R.C. Curtis intentionally or knowingly caused the penetration of the mouth of Paula Boyd, a person who was 65 years or older at that time, by R.C. Curtis's sexual organ, said act having been committed without the effective consent of Paula Boyd, in that R.C. Curtis compelled Paula Boyd to submit or participate by the use of physical force or violence, and while in the course of and in furtherance of the commission or attempt or an immediate flight from the commission or attempted commission of the offense, R.C. Curtis did then and there commit or attempt to commit an act clearly dangerous to human life, to wit, by strangling Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and/or by strangling Paula Boyd with an object unknown to the grand jurors that in the manner of its use or intended use was capable of causing death or serious bodily injury, and/or by striking Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, or with an object unknown to the grand jurors, that in the manner of its use or intended use was capable of causing death or serious bodily injury, in such act, clearly dangerous to human life, thereby cause the death of an individual, namely Paula Boyd, or the defendant R.C. Curtis did commit or attempt to commit the felony offense of robbery, and while in the course and furtherance of, or in immediate flight from the commission or the attempted commission of this offense of robbery, R.C. Curtis did then and there commit or attempt to commit an act clearly dangerous to human life, to wit, by strangling Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and/or by strangling Paula Boyd with an object unknown to the grand jurors, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and/or by striking Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, or with an object unknown to the grand jurors, that in the manner of its use or intended use was capable of causing death or serious bodily injury, in such act clearly dangerous to human life, thereby cause the death of an individual, namely Paula Boyd, or the defendant R.C. Curtis did commit or attempt to commit the felony offense of injury to an elderly individual against Paula Boyd, a person who was 65 years or older, while in the course of and in furtherance of the commission or attempt or immediate flight from the commission or attempt of this offense, R.C. Curtis did then and there commit or attempt to commit an act clearly dangerous to human life, to wit, by strangling Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and/or by strangling Paula Boyd with an object unknown to the grand jurors, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and/or by striking Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, or with an object unknown to the grand jurors, that in the manner of its use or intended use was capable of causing serious death or serious bodily injury, in such act clearly dangerous to human life, thereby cause the death of an individual, namely Paula Boyd, or the defendant R.C. Curtis did commit or attempt to commit the felony offense of aggravated assault against Paula Boyd, a member of R.C. Curtis's family, and while in the course of and in the furtherance of the commission or attempt or in the immediate flight from the commission or attempt of this offense, R.C. Curtis did then and there commit or attempt to commit an act clearly dangerous to human life, to wit, by strangling Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and/or by strangling Paula Boyd with an object unknown to the grand jurors, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and/or by striking Paula Boyd with a deadly weapon, namely the hand of R.C. Curtis, that in the manner of its use or intended use was capable of causing death or serious bodily injury, or with an object unknown to the grand jurors, that in the manner of its use or intended use was capable of causing death or serious bodily injury, in such act clearly dangerous to human life, thereby cause the death of an individual, namely Paula Boyd, then you will find the defendant R.C. Curtis guilty of the offense of felony murder as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the offense of felony murder as charged in count 2 of the indictment. You are instructed that if there is any testimony before you in this case regarding the defendant's having committed an offense or act of misconduct other than the offense alleged against him in the indictment in this case, You cannot consider said testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such offense or act of misconduct, if any were committed, and even then you may only consider the same in determining the motive, intent, and or identity, if any, of the defendant, if applicable, and for no other purpose. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by witness to investigators or officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of the law made by counsel, if not in harmony with the law stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience, if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this case, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your questions to the court in writing. If you wanted to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas. Suitable forms are attached. All right, ladies and gentlemen, each side will have 20 minutes to present closing arguments to you. Before they begin, is there any juror who needs a break? All right, State, are you ready to proceed?
Yes, Your Honor. The state would like to make an initial argument and then reserve the rest of our argument for rebuttal. Morning, folks. Now, you just heard the reading of the charge. It's a mouthful. It's a lot to go through. So what I'm going to try to do is break it down a little bit for you, because some of the things you're going to see over and over and over in the charge. So I want to try to make that as clear as I can. Now, first of all, you have two counts in this case. Count 1 is capital murder, and count 2 is what we call felony murder. Now, what I want to do next is talk about, in each count, we have paragraphs. In count 1, the capital murder, we have 2 paragraphs. In count 2, that's the felony murder, we have 4 paragraphs. Now, this issue we talked about during voir dire. And I think it was, I can't remember if it was prospective juror number 21, somebody said when the issue came up, well, why do you have the various paragraphs? And that juror said, well, isn't it their job to do that? Isn't it their job to put forward the theories about why this offense was committed? And that's exactly right. The reason that we have multiple paragraphs is not because we're throwing things against the wall, it's because the facts fit those paragraphs for what he did. That's why we do it. Wouldn't you want us to be thorough and have those types of theories presented to you, to give you, the jurors, those options, those abilities to prove the case? Now, another important aspect is that you have to return a unanimous verdict in regards to the counts, not the paragraphs, as to the counts. For example, count 1, you have paragraph A and you have paragraph B. 6 of you can say, I believe he, with paragraph A, that's committing the aggravated sexual assault and also intentionally causing the death of Paula Boyd. And then 6 of you can say, well, I believe he intentionally caused her death while in the course of committing robbery. That equals guilty of capital murder. You don't have to be unanimous on paragraph A. You don't have to be unanimous on paragraph B. As long as all of you agree that it's one or the other, it equals guilty. Same thing goes for count 2, the felony murder. We have 4 paragraphs there. Aggravated sexual assault, robbery, injury to elderly, and also the last one is aggravated assault against a family member. Same thing. For example, 3 of you could agree on the first one, 3 on the second, 3 on the third, 3 on the fourth. You don't have to be unanimous in terms of the paragraphs, only the counts. As long as you all agree on the count, it equals guilty. You also have heard throughout the trial, and also in voir dire, and the judge read it here on the charge, the term deadly weapon. Now, we talked about that. A deadly weapon is anything that in its use or intended use is capable of causing death or serious bodily injury. And you agreed with us when we gave the examples that essentially anything can be a deadly weapon. Here what we have in the indictment, hands, and also objects unknown to the grand jury. We know that Paula Boyd met with a very ugly death. We know because of the various injuries that she suffered that it caused her death, thus meeting the definition of deadly weapon. Now, also in all the counts, both in count 1, both paragraphs, and in count 2, in all 4 paragraphs, you're going to see the same type of language over and over. And that's why I want to try to distill this as much for you as I can. The way that we're proving this is, 1, that she was strangled in some form or fashion, either with the hand or an object that we don't know, but we know that she was strangled based upon the testimony of Dr. McLean, or that she was struck with the hand of the defendant or an object unknown to the defendant. You saw those pictures. You saw how she was beaten, that she bit through her actual mouth. Like, you can see the tooth protruding. You can see her tongue. You can see that lip shredded, as Dr. McLean testified to. You know that she met with an ugly death by being beaten. Now, I want to distinguish between what is capital murder and what is felony murder. Capital murder is when you intentionally cause someone's death in the course of committing a certain felony. Now, the ones that we give to you are aggravated sexual assault or robbery. Now, aggravated sexual assault, in this case, what we've had in our indictment, and in that paragraph, is paragraph A, count 1, is when you commit a sexual assault against somebody who's 65 years or older. We know Paula Boyd was 75 years at the time of her passing.
5 minutes.
Thank you, Judge. And then now switching to, and then you're committing rape. The next part is robbery. It's when you take something from somebody while committing some type of bodily injury. In this case, we know that her purse was taken. We know that her credit card was used on the same day, actually while they're processing the crime scene at 8558 Heber. We also know that Paula Boyd's cards ended up in the hands of David Rocha, and also Donald Lee Barnett's in that as well. Now, distinguishing capital murder from felony murder is when somebody's committing a certain crime, either aggravated sexual assault, robbery, injury to an elderly, or aggravated assault, and in the course of committing that crime, or in the immediate flight from committing or attempting to commit that crime, the person does an act clearly dangerous to human life that leads to her death. So the big distinguishing factor between the two is, did he intend to cause her death while committing aggravated sexual assault or robbery? Or was he just doing some other crime and did an act clearly dangerous to human life that led to her death? The issue is his intent to cause her death. That equals capital murder. Quickly, evidence is items that were marked and admitted as evidence that can come back to you, like the video, the photos. Evidence mostly is from that witness stand, from what you heard. What is not evidence is argument. What you are to consider is what came from up here, as well as the evidence that was submitted to you. Folks, I appreciate your time. I'm going to take a seat. Mr. Bunk will do his argument now. Thank you.
Morning. So I told you a while back, my name is Charles Monk and I love my job. Today, not so much. I have 20 minutes, and in those 20 minutes, I have to talk to you. And what I have to say affects the rest of his life. His life is literally in my hands, and I've got 20 minutes to save it. Now, the difference between me and them is the number 20 and this number. $3,589. That's how many days they had to prepare. That's how many days they had to say, whatever we have, we will bring to you. And this is what you got. This is what you got. And I've got 20 minutes to try to explain to you why it's just not enough. What is this evidence? What is this evidence that is enough beyond a reasonable doubt to convince you that he is guilty of these crimes? And let's talk about paragraphs and counts. It doesn't matter. Either you believe this story or you don't. And it comes down to two things: the DNA and those two guys. And people said in voir dire, you know, we're really skeptical about DNA. And I thought, okay. And then I heard from Jamie Pomacall, who said, I would have never even written a report about sperm if the cops hadn't told me to. And I thought, well, God, no wonder people are skeptical about DNA. The cops tell them what to do. There would have never been a sexual part of this case at all if the cops hadn't told the crime lab to do it. That's how weak their opinion of the sperm evidence was. But yet, here we are, because Detective Hines told them to do it. And I'd like to tell you, well, at least take comfort that Detective Hines is really, really good at his job, and if he says it is so, you should find it that way. But I'm not comforted in that either. Because we listened to his testimony together, and I think we all agree that's not the case. Because what did he do? Well, he made a rush to judgment about this guy. It had to be him. Well, I said, what about these other people? What about David Rocha? Is he a suspect? Absolutely. Well, did you find him to be honest or dishonest? He's dishonest. Well, what about searching his apartment? No, I didn't need to do that. What about his cell phones? Now, at the time, I asked him that you didn't know what you later learned. I didn't search his cell phones, and he was never going to be able to, because as soon as David Rocha learned about all this, what did he do? He hightailed it out of here, and the first thing he did on his way out was break all of his cell phones. So that was never going to happen, and who else? Well, there's Frank. He's a suspect. He refused to talk to anybody. He didn't get searched. His phones were tracked. They said, oh, well, yeah, you can't carry. His phones were, he was over there, but it's okay because his mom also lives by. But I didn't have probable cause. He's a suspect in a capital murder, but I didn't think I had probable cause to search his house. And then there's this guy. Antonio Jones. Now, physically, he's a tall, skinny black guy. Now, what's important about Antonio Jones is several things. First, his physical description. Now, remember, there was a conversation about his mom. His mom's name is Christina. And there's an event at a party where a video is discussed. And Christina slaps her boyfriend Robert about filming something. Literally, she slaps him. Y'all filmed that? And then at some point later, this tall, skinny black guy kills Robert. He kills him. And he's in prison for that murder. So a guy who filmed something is killed by a guy who fits the description of being in a video of a murder. Now let's talk about that alleged video. This guy's Scotty Perez. Now, the detective says Scotty Perez calls and talks to the police. Now, unlike Rocha and Barnett, who clearly had something to gain from cooperating, right? Start with Barnett. He says, dude, I would have said anything. And Rocha got a deal as well. Perez got nothing. There was no testimony that Perez called and said, hey, what's in it for me? Is there a Crime Stopper tip? Do I get anything? He just said, hey man, I need to tell somebody. I saw this video and it's horrible. And then he describes what he saw on the video. Two tall, skinny black guys, ironically, or in this case, not ironically, Antonio Jones, who killed a guy who filmed something, a tall, skinny black guy. And what does Scotty Perez describe? Two guys kicking and beating this woman to death. Now, how would Scotty Perez know how Paula Boyd died? How would he know if he hadn't seen the video? Now, fast forward to Dr. McLean's testimony. How was she killed? Kicked and beaten to death. Her broken ribs. Now, they want to tell you that because Fat RC sat on her, that broke her 15 ribs. When I asked him, also consistent with somebody kicking her when she's down? Absolutely. She's beaten on both sides of her face. Consistent with two guys doing it? Absolutely. How would Scotty Perez know that if he hadn't seen the video? Think about that. Now they want to say, oh, it never happens. Scotty Perez made all that up. Really? It's just a coincidence? There cannot be coincidences that are that close to the facts. There can't be. We're going to bring you everything we have. Well, I'm still waiting. It's a capital murder. What did you get from the crime scene? Glasses. Glasses! What about this? What about this towel? What about anything? They're going to tell you the towel has nothing to do with it. Well, how do we know? How do you know? So you got two guys that come in, beat her to death in the middle of the day. She's going to scream. What stops that screaming? This towel. This towel. Could that towel have his DNA on it? Absolutely. Who says so? Their expert. If she's going to pull the towel out of her mouth, in this picture, what hand does she use? Her left hand. What hand's extended? Her left hand. Where's his DNA? Under her left hand. Is that a coincidence? They're going to tell you, of course, it's just a coincidence. How do we know? We can't know. You can't know because you got glasses. They tried, Stephen, like, oh, well, DNA can't last 20 days. It can last 30 years, he said. So let's talk about RC. Darrell says you can make logical inferences from the facts. What on earth does this man have to gain from doing that? He's going to get up and preach about how he doesn't have to prove motive. And he's right. But you can ask yourself, let me get this straight. Santa Claus, her Santa Claus, takes his kids to school and says, you know what? I'm going to go over and beat my kid's great-grandmother to death and rape her. For what? He has his own money coming that night. They have a great relationship. Everybody told you that. Everybody told you. If there was ever any evidence that he was ever mean to her, you would have heard it. There's no evidence. He cleaned her house. He drove her on her errands. No evidence. And speaking of no evidence, they're going to tell you, because her card was used on Huebner, and he says he went to a convenience store on Wurzbach or Huebner, it had to be him. Why? Why does it have to be him? Where is the evidence? Where is the evidence that he used that card on Huebner? Where? 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 Where is the evidence in his statement? And also, he went down and talked to the police voluntarily. I'll answer all your questions. I challenge you to find one thing they can prove to you that he lied about. Where is one thing that he lied about? One thing. Did they bring you evidence that anything in his statement was a lie? No. Not one thing. Nothing. So, 3,589 days later, we start this trial, and that's what you got. They're going to get up and say, this poor lady deserves better. She deserves justice. And she does. She absolutely does. I feel so sorry for Paula's family. I feel sorry because she's got a daughter that's sitting over here, and she's got a daughter that is sitting over here. And I feel terrible for them because they deserve better. And I feel terrible for him because they might get away with this. Everybody, you deserve better. The community deserves better. I'll tell you what I do know, sadly, if this was David Robinson's grandmother, you'd have gotten a lot better. That's what I do know. It's very, very sad. They told you, or I told you actually, they're going to tell you, take this leap of faith with us.
5 minutes.
Thank you, Judge. I didn't realize at the time that they were going to be pushing you off of Mount Everest when they told you to take this leap. They're going to get up and say the DNA is rock solid. It's rock solid. He was there. Well, yeah, he was there. He's there all the time. His laundry is certainly there all the time. Erica brings his laundry over all the time. All the time. They do their laundry there. He may have been there October 1st. I don't know when Erica last brought the laundry, but JD told you they bring the laundry all the time. Just like JD told you, we like RC. RC helps my grandmother all the time. What did JD not tell you? He's mean to her. I'm scared of him. We're scared of him. Nobody is scared of Santa Claus. He just woke up one day and did this? Come on. Come on. How could they have proven this? They could have swabbed her neck for DNA. That would have told you something. Didn't. Even today, right now, he asked you, wouldn't you want us to be thorough? Yes. Yes. Beyond a reasonable doubt means there's no other explanations. There's no other suspects. Well, there are other explanations. There are certainly other suspects. I hope you don't think throughout this ordeal I wasted your time, or I took too much time, or I objected too much. But I've been with RC throughout this ordeal for a long time. And if he looks nervous, it's because he is. He is. I know they're going to get up and tell you that I'm just making shit up. But I'm just saying anything. The evidence doesn't support what I'm saying. And actually, and sadly, part of that's true. I can't tell you the towel supports my theory because I don't have it. But their witnesses tell you the towel could support my theory if I had it. The evidence does tell you they told the lab to change their report. Scotty Perez tells you, I saw the video, or he saw the video that describes the assault the medical examiner describes. How? How? Leon Rocha, he's going to tell you, well, they told you exactly what happened. Really? You're going to convict, you're going to send this guy for the rest of his life in a cage on those two guys? Their testimony is going to put him in a cage for life? Those two guys? Really? Come on. It is terrible what happened to her. I agree. Somebody has to pay. I agree. But just because the government says it's him, that doesn't make it so. Please tell them, just because they say it is, doesn't make it so. And in this case, it's not so. Thank you.
How much time do I have, y'all?
13 minutes and 16 seconds.
Thank you. Good morning to you, ladies and gentlemen, and Mr. Bunk is right about the approach I'm going to take. He's had my job. Because he's had my job, he knows what he can intimate, he knows what he can suggest. You saw it. You saw it over the course of this trial. You heard it from the first time he got up here. You saw the confusion. You saw the nonsense that got generated. What you need to do when you go back and deliberate is separate all that noise, all that confusion, the maps, etc., that didn't come in because they don't mean anything. They didn't prove anything. What you need to do, pardon the pun, is ignore all the bunk and focus on what we know to be the facts. The fact is 75-year-old Paula Boyd, handicapped, who still worked at 75, was always regular, on time, so much so when she didn't show up for her 1 o'clock appointment, people got worried and they went to find her. You know that Gracie DeWalt, before 3 o'clock, got there, found the police when they arrived. There is an evidence. You saw the picture from the clock, 3:09. You heard from the medical examiners that with rigor and all of it set in, she could have died as early as 8 that morning or 9. So when does a woman who has to be driven across I-10 to get to her job, driven to the bank, how does she get to 8558 Hebner where her card is used? Cards that were never found, not by the detectives on the 21st, not by Brenda when she got in to clear out her apartment. Where's the purse she carried every day? When you listen to his statement, he knows where his unemployment card is. It's right in my doggone wallet. But we don't find any identification from Paula Boyd. You know, he is the one that gave it to Lee and Rocha the next day. Within 72 hours, he's trying to get that hot evidence out of his hands. And oh, by the way, running down Barnett, listen to his statement. Lee is his alibi on Wednesday. I was smoking a cigarette with Lee. I was going to borrow some money from Lee. I'm going to do all this with Lee. Lee's his alibi. And now when Lee finally finds out what that man got him into and decides to tell the truth, tell what he did in this crime, now all of a sudden Lee is making it up. Lee's his alibi. He's the one that tells you about Lee. That's the nonsense. That's the bunk you need to remove. RC's phone is nowhere near Paula Boyd's. He tells the police, I hadn't paid my bill in months. My phone didn't come on till 9:30 Wednesday night, the 21st. And that's supposed to exonerate him? That's the nonsense. I told you when we started what we had to prove, and I'm standing here, ladies and gentlemen, to say the evidence proves it. And so I'm asking you, when you go back to deliberate, when you get to that jury verdict, you drive past that first paragraph and you go to the bottom one, Mr. and Ms. Foreman, and you find him guilty of capital murder because he sexually assaulted a 75-year-old woman who was so impaired, so infirm, he killed her literally on top of her cane. I know of no other way that spermatozoa, the first fluid Jamie identified, sperm. I know of no other way that sperm leaves the male body other than through its sexual organ, and it is deposited in her mouth. The doctor told you 15 rib fractures, 8 on the left side, 7 on the right side, a heavy weight pressing down, breaking her while he pounds on the right side of her face. And in that moment, when he sat his words, 340 pounds, when you look at the video, Look at those ham hocks he had for arms. And she was able to get his DNA under her nails. Spiral fracture at C7. Paralyzed her instantly. He told you it was serious bodily injury. And it killed her. You know why? Look at how she was found. The pictures of the bathroom, that flowery road. She knew she had to go to work at 1. Yes, as they pointed out. The maintenance man saw her watering her plants at 8. She's getting ready to go to work. Autopsy, time of death. When could she have gone to do it? And where are her documents? He went there after dropping the kids off at school, after dropping his wife at career point, when he has no alibi. He's unaccounted for. And he goes over, let me have the card, let me use it. She finally, in 75 years, said no, and he went off. And he left there with that evidence. He left with that purse. He left with her cards. And oh, by the way, 8558 Hebner, you heard the detective, at least 3 miles away. She can't get there and get back to be killed when the medical examiner says she's killed. He did it. When he talks about, oh, well, Lee was then going over to his mother's house in Wurzbach and he's going to lend me money, but he called me. His phone isn't on till 9:30 at night, so how does he get a phone call from his alibi when he tells police? He can't keep his lies straight when you know the whole story. And oh, by the way, I was going to Wurzbach and Hebner. That is called a lie. He was at 8558 Hebner. You know, because you got his bank records. He didn't check his balance nowhere. That's how you know he's lying. Because of the story he made up that doesn't fit the evidence. And so if for some reason you decide you can't get to capital murder, we have given you evidence and proved felony murder every way we could think of. And Steve told you why. But that man, right there, watch his statement. Go from what you know.
5 minutes.
Spermatozoa can stay in her mouth for 3 weeks. Come on, man. Be real. And yes, you heard Barnett say, why did I tell Stacks, the other person, didn't want to cooperate? This is how he left her. This is how he wants to believe. And it's unfortunate about murder trials, we have to go there. That's how she needs to be remembered. With the people who loved her. Somebody hadn't been there in 3 weeks, but Mijo, her grandson, who just saw her Monday, 2 days before left, he's got no DNA on her body. This is how she needs to be remembered. With the community she served, the customers who loved her, the people who loved her. She is calling out to us from heaven. He did it. He did it. Let me rest. I told you this from the beginning. The evidence supports every step you need to make. And I am asking you, you know it's what happened. Ladies, you know where you carry your documents. They never found them because he took them. Because he gave them to Barnett. Because he knew, let me put somebody else on video. Let me put other people between me and them. He did it. He comes off all shucks, he's slick. Nickel slick. She's trying to get to work. He interrupts her. She finally says no. He's waiting for his unemployment. Think about that. Some may say it's a cheap shot. It's also the truth. Those are facts. I'm coming back again. You know the evidence. Yes. The sin is 3,589 days. I join in and agree with that. Because that's the system, I bear that, I'm the one that you look to for responsibility. But we never wavered. We fought through it all to get here to this day to finally tell Paula Boyd's story. To finally stand for her family. Yes, even Marty, I know she disagrees with me, but I know she misses her mother. And this is the evidence I have, the admissible evidence. That is why I am asking you, when you come in to deliberate, come back with the only verdict the law and the evidence provides. I am asking you to find him guilty of capital murder. If you can't get there, that he intended to kill her and committed this other act, then he intended to do the theft. He intended to do the assault on an elderly. He intended to do the assault causing serious bodily injury to a family member. He intended to do the sexual assault. And then she died. Felony murder. I'm asking you to follow the evidence and find the verdict of guilty. Because you know he did it. How do those other two get the cards the day after while the autopsy's being done? And they said they got it him. And before you start condemning him, again, Barnett is his alibi. Who, when he finally figured out what this guy got him involved with, he said, hell to the no. Yeah, I'm coming clean. And Barnett got Rocha, where they smoked the meth at his house. It all fits and makes sense. He's it. Everybody else admitted to the cards. We got two people that said he got them. He's the conduit. No one else. I thank you for your verdict.
Ladies and gentlemen, if you'll meet me on this side, there are two of you I'm going to ask to remain behind. And Cindy, we're off the record.
All rise to the jury, please.
before that. Arson. He lit up the two houses. Check this thing. My peeps over there. Yeah, he lit the two houses. Sancho. So the Sancho.
All rise.
All right, everyone, please be seated. All right, we're back on the record in 2019 CR 10230, State versus R.C. Curtis. Could I have parties announce?
Daryl Harris, Stephen Spear, and Alexander Butters from the State Yard.
And for the defense?
Charles Buck, Lindsay Shaw for Mr. Curtis, who is present in the courtroom.
All right, it's the court's understanding that a verdict has been reached in this case. This is what I'm going to tell all parties in the audience. Number one, I realize that this is very emotional for everyone involved, but there is not to be any type of noise associated with the verdict when I read it. If there is an issue, then you're going to be asked to leave the courtroom, and you will not be allowed back in the courtroom. Does everyone understand?
That's right.
All right, Deputy, if you could line the jurors up.
Yes, ma'am.
If you look at them. All right.
All rise for a jury.
All right, everyone, please be seated. Ladies and gentlemen, it's my understanding that you've reached a verdict in this case. Is that correct?
Yes.
And is your verdict unanimous?
Yes.
All right, if you'll give the verdict form to the deputy, please. Thank you. Could I have parties approach, please? Step back in the jury room for a moment, and then we'll bring you back out, all right? Everyone, please rise for the jurors. All right, everyone, please be seated. State Defense, if you all could come forward, please. Thank you. All right, let's bring them in.
All rise for the jury.
All right, everyone, please be seated. Ladies and gentlemen of the jury, in order for the court to receive your verdict, both verdict forms must be complete. Does everyone understand?
Yes.
All right, then the deputy will take you back to the jury room. All rise for the jurors. All right, everyone, please be seated. Ladies and gentlemen, have you reached a verdict in this case?
Yes.
And is that verdict unanimous?
Yes.
All right, Deputy. Thank you. All right, the verdict form reads, Count 1. We, the jury, find the defendant, R.C. Curtis, guilty of the offense of capital murder as charged in Count 1 of the indictment. Count 2. We, the jury, find the defendant, R.C. Curtis, guilty of the offense of felony murder as charged in Count 2 of the indictment. You may be seated. Does anyone wish to have the jurors polled?
Yes.
All right, ladies and gentlemen, I'm going to ask you if this is your verdict. If this is your verdict, respond yes. Does everyone understand?
Yes.
All right, I'll start on this end. Is this your verdict?
Yes.
Is this your verdict?
Yes, ma'am.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? I'll go to the back row at the end. Is this your verdict?
Yes, ma'am.
Is this your verdict?
Yes.
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 All right, thank you. The deputy will escort you out of the room, and I'll meet you in the jury room in a few moments.
All rise for the jury.
All right, everyone, please be seated. All right. Mr. Curtis, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
All right. In this case, the jury has returned a verdict of guilty to counts 1 and counts 2. The court will set aside count 2. Any objections to the court setting aside count 2 state?
No, Your Honor.
Defense?
No change.
All right. Then, with regards to count 1, any objection to proceeding with sentencing?
No change.
All right. Then, being that count 1 is a guilty for capital murder, the court will sentence you to life in prison. Is there anything else with regards to sentencing?
No change.
All right, Mr. Curtis, you've signed the trial court certification of defendant's rights to appeal. You do have a right to appeal as this were due to the fact that this was a jury trial. Do you understand?
Yes, ma'am.
All right. All right. Yes. Yes.
Do you have one representative of the family like that victim impact, Your Honor?
All right. So, Deputy, they say they want to do a victim impact statement. All right. So, what I can tell everyone is that I require that everyone treats everyone with respect. And so, you may proceed.
Okay, I'm reading the statement on behalf of the family. It has been nearly 10 years of pain of our loss and worry over this trial. In that regard, the family would like to take this opportunity to honor Paula Boyd by following her example. We pray that all who commit crimes confess their sins, pay their penalty, and receive forgiveness and absolution before God. Please do this before it is too late, is what Paula would want. That's it, Judge.
All right, thank you. All right, Mr. Bach, do you need to speak with your client or collect any items from him?
Yes, please.
All right, so the deputies will take him in the back and you can
Thank you, Judge.
go to the back with him. And for the state and the defense, Mr. Bach, I'm going to go speak with the jurors, and if anyone would like to speak to the jurors,